Hello, everyone. Welcome to today's webinar on Crash Course Contract Law. It is day 2 of our 5-part series, and today we will be learning about two topics, differing site conditions and change orders. If this is your first time watching our webinars, welcome and thank you for being here. We hope you learn a lot today, and if this is your second, third, or fourth time with us, welcome back. We'll take that to mean that you're getting a lot from these sessions, and we hope to keep doing the same, for the next several months. So my name is Ingrid Velasquez. I'm the Chief of Content and Marketing for Fohlio. I'm sure some of you already know me quite well. I'm also seeing a lot of familiar names here today. For those of you who are hearing about us for the first time, Fohlio is a platform for architects, designers, engineers, contractors, vendors, and everyone in the design build industry. Fohlio makes product specification easy and efficient, and our software also helps streamline the creation of product schedules, purchasing, invoicing, creating documents, and more. If you would like to know more, please go to fohlio.com. We'd be happy to set up a one-on-one demo with you. So today we again have Wally Zimolong. He is a lawyer for the real estate and construction industries. He has successfully litigated hundreds of cases and has counseled clients all over the country on developing and constructing highways, multifamily apartment buildings, professional and collegiate sports stadiums, schools, and uniform planned communities. He has tried numerous cases to verdict and boasts an undefeated jury trial record, which is pretty awesome. So after Wally's lecture, I do also have a super short presentation of my own, and it'll be about a few tips on how to stay on top of documents and keep everyone involved in the project on the same page. So like I said in the last session, our goal with today's webinar and the following sessions of this 5-part series is not to turn you guys into lawyers or have you be more knowledgeable and educated than lawyers. Rather, we would like to help you be more familiar with contract language, and especially language that puts you or your own firms at risk. Also, please don't take this as us helping you protect yourselves against contractors or designers or subcontractors. And instead, think of this as a way to help everyone be on exactly the same page so that everyone knows what they are agreeing to and everyone's interests are protected. Ultimately, the goal today is to prevent contract disputes because those cost a lot of money, especially if you go all the way to litigation in court. Before I hand the presentation over, please remember that you can type in your questions in the little question box on your screen, and we will have answers for you after the session. And without further ado, here is attorney Wally Zimolong.
Thanks, Ingrid. For those of you that didn't join us last time, the session last time we touched on payment terms and conditions, scope, price, and time in a contract. And today we're going to talk about differing site conditions and change orders. And these concepts relate very closely to the topics that we discussed in the last session. And for those of you that joined in the last session, you may recall me mentioning that it's critically important that you get the scope of work in your contract correctly. You need to indicate to your client just exactly what work is being performed, and your client needs to know exactly what work you are agreeing to perform for the price that the client is paying you. And I said that's important for a number of reasons, and one of which Ingrid touched on, is that clients by far overwhelmingly come to me after a dispute arises. And if they had spent time with me before and were aware of how critical it is to define specifically the scope as best as possible, they would have saved themselves a lot of money on me and probably would have ended up getting paid, and they wouldn't even have to come to me in the first place. And I think Ingrid actually brought up another good point as to why it's important to understand contract language and understand how these common clauses on a construction project work is in avoiding disputes, is important. We all want to avoid, unfortunately, clients want to avoid me, but it seems like they can't help themselves. Um, and lawyers are expensive and all that, and we're not trying to make you an expert. One thing I think that Ingrid touched on is it is important that everybody is on the same page, because at the end of the project, you don't want to be dealing with a client that has a bunch of claims. You want to be dealing with a happy client, and you want to be dealing with someone that comes back to you and wants to hire you again, and someone that you foster a long-term relationship with. So how do you do that? How do you accomplish all that? And where do we see areas where that isn't accomplished, or where people leave really unhappy and angry at each other, and even if they don't go and seek an attorney? We see it in the area of what are called differing site conditions and change orders, and both of those concepts are closely related. So basically, when we talk in terms of differing site conditions, is what happens when, if you're a contractor, you're performing work on a project and you encounter conditions in the field that differ from the drawings that you were provided, or what was represented to you as to the conditions being, or something that you just couldn't reasonably anticipate encountering on a project. That's known as differing site conditions. And whether or not you will, and differing site conditions, and why it's the change orders concept is related to it, is when a contractor encounters differing site conditions and the work that it is required to perform is different than the work that it anticipated when it presented its proposal, that's going to lead to change orders. It's going to lead to change orders, and it's important that the change orders get paid from the contractor's perspective, because it could be the difference between a profitable or unprofitable job, and then the change orders are significant enough. You're talking about mission critical payments that could continue the life of a contractor. And then from the owner's perspective, there's nothing the owner hates more than the contractor that comes to them and says, I have all these changes to the contract. I couldn't have anticipated encountering these, and it's going to cost you 25% more to complete your project. So both parties have a lot at stake in change orders, and it's a fertile ground for dispute, and it's a really fertile ground, for emotional disputes as well. So depending on, no matter whose side you're on, how do you understand the concepts, and how do you avoid the disputes? Well, the first thing that you need to understand is you got to understand if the contract addresses when a contractor will be compensated for conditions that are encountered that differ from what was presented to them to prepare their bid, what was indicated on the drawings prepared by the design professional, or just what could be reasonably anticipated. And the change condition concept varies from project to project, but in all projects, there is the potential for these change conditions. If you're talking about a modest residential home renovation, a change condition could be you take down a wall and you did not anticipate or reasonably anticipate there being sort of load-bearing beams, and that requires you to engage the services of an engineer, and then also perform all sorts of additional work to compensate for the loss of that load-bearing partition. And that wasn't reflected on the drawings or other documents that you were given in order to prepare your bid. And then on the larger end of the spectrum, it could be where I often see it with my clients who are performing heavy highway work, and they're going to dig some deep trench into the ground, and they encounter rock instead of just ordinary soil, and they're forced to do blasting and a considerable amount more excavation than they anticipated. Both of those concepts are examples of change conditions. And the first place we're going to look is to see if the contract covers what will happen if changing conditions are encountered. If you have a contract, or you're looking to draft a contract that you're working on, and it doesn't have a change conditions clause, it probably should. You probably should set forth before the relationship if the parties are, if you're going to get paid, is the owner going to be paid for change conditions? And if so, what conditions are going to be paid for? Generally speaking, in a contract where an owner agrees to pay a contractor for change conditions, a owner will agree to pay a contractor for two types of change conditions. First are those conditions that differ materially from the conditions that were disclosed to the contractor at the time of bidding. So to use the example of the residential project, an architect prepares drawings. The drawings don't indicate that the wall that needs to be removed is a load-bearing partition, and the contractor goes out and discovers it's a load-bearing partition. That would be the type of scenario that you would encounter there, where if there was a change condition clause, the owner would have to compensate a contractor for that work. The other type of change conditions is a little bit more subjective, which is the conditions that are unusual, unknown, or unanticipated. Now what could that be? Well, I'll give you one sort of esoteric and kind of wild example, but one that actually is real. I had a project that I was working on in Philadelphia, and Philadelphia, like many cities on the East Coast, is an older city, and they were building a townhome community. They started excavating, and they started to find human remains. And what had happened was that this land had gone back to the founding of the city, and at one point there was a church over 100 years ago that was located on this property, and as was the custom at the time, is that many of the parishioners were buried right next to the church. And then the church was abandoned and it moved, and those that were wealthy enough to have gravestones, those bodies were interned to another location. But those parishioners that were buried in sort of the potter's field of the church grounds, their remains were left, and they were encountered by the excavation contractor. So what do you have to do? Well, you have to respect those remains and do your best to follow the procedures that are and customs that are necessary to remove them in a careful manner and place them respectfully in a proper cemetery burial ground, even though they were hundreds of years old. That would be something that was unusual, unknown, or unanticipated. That's an example of that. Clearly, on the architect's drawings or the civil engineer's drawings, there wasn't any indication that you can anticipate bones to the ground. You could argue you could have anticipated certain geological formations, or the fact that there may have been an existing foundation from a prior building there, being that it's in the city. But nobody really could reasonably anticipate uncovering human remains. And why that would be the basis for a change order is that the project has to stop, and authorities have to come in, and needs to be investigated. So it's taking longer, and there's additional costs with getting the specialized folks out to the site to take care of those remains. So that's the first. They're the two types of examples that if you have a change conditions clause in the contract, that's when you'll be compensated if you encounter those two types of conditions. Now, there are many contracts that don't have change condition clauses. And when I'm representing an owner and I'm asked to draft a contract, I'm trying to shift as much risk down to the contractor. And I don't want my owner having to pay for a bunch of change orders at the end of the project when they've paid an architect to prepare drawings. And how do you do that? Well, and on the flip side, if you're a contractor and you see these site investigations and disclaimer clauses in the contract, you should be aware that if you encounter conditions that are different from the drawings or different than what you could have anticipated, if you have the other end of the spectrum type of contract that includes a site investigation or a disclaimer, then you need to know that you're buying what you don't know, and you might not be entitled to additional costs or additional time if you encounter conditions in the field that differ than what what you could have reasonably foreseen or anticipated. So when we talk about site investigation and we talk about disclaimer clauses, what are we looking for? Well, a common type of site investigation clause will say that the contractor has investigated the site, they've had full access to the site, and they've made themselves familiar with the site so that they're not going to come back and say, well, I didn't know that I didn't know the load-bearing wall was there. If you have a site investigation clause and you represent the owner, you're going to say, listen, I gave you a chance to investigate this fully. If you had any questions, you were the expert. If you had any questions or you needed to take measurements or calculations or you weren't sure about certain things, then you had your opportunity prior to entering into this contract, and you've in fact affirmed in the contract that you've investigated the site and you were satisfactory with its conditions. And then there'll also be either in a separate clause or in the same area of the contractor disclaimer saying that, hey, we're not making any representations as to the completeness of the architect's plans. If you're concerned about that, to do your own investigation. We can't promise that the architect has picked everything up, and don't come to us with change orders if you encounter something that's different from the plans or different than what you anticipated to be there when you took down the wall. Those are the types of clauses that I always put into my contracts when I'm representing an owner, because I'm trying to limit the risk that the contractor come back and say, hey, I didn't know that load-bearing wall was there. I can go back to the contractor and say, what are you talking about? You signed a contract that said you investigated the site. You also signed a contract that said that the architect's drawings were not deemed to be complete and perfect. So, and you also signed a contract that said you're not going to seek a change order for that. So go pound sand. So you need to be aware of that, because if you're a contractor that's receiving a contract like that, you're assuming a significantly higher amount of risk there. And when you do assume that additional risk, you're going to want to make sure you price the project accordingly. You can't price it the same way that you price another job saying, well, if I encounter something, well, I'm just going to get a change order like I do on other jobs. No, you're not. So just like anything else, just like any other commercial transaction, you have to price in that risk premium. So be aware of that. Anything that says that you are investigating the site or that you're taking the site as is, where is, and any sort of disclaimer that the drawings aren't full and complete. If you're on the contractor's end or the person that's receiving that contract from an owner or a higher tier contractor, that's definitely a red flag for you. You're going to want to talk to somebody about what that means and what you might do to mitigate the severity of that of those clauses. Because like I said, it's a significant amount of risk that you're assuming by your contract when you sign a contract with those disclaimers. So now that you have an understanding of when you might not be able to recover additional cost and additional time for change orders, you move on to the change order clause, and it's just like the main contract itself. When we're looking at change order clauses, we're asking who, when, and how of change order claims. So you want to find out who is authorized to direct changes, what are your deadlines to submit change order claims, and how must those claims be submitted. And this process is going to become more sophisticated based upon the size of your project. I think if you were to put this on a graph, if the price represented the vertical axis and the complexity of the change order process represented the horizontal part of the axis, you would see it move in a linear fashion. As the price of the project, the cost of the project went up, it would move correspondingly with the complexity of the change order process. But it's nonetheless important to understand it, and that even on a smaller project, a basic, could just be a home renovation project, you might not need to have something terribly sophisticated, but you need to have something in there that says, if I'm going to request a additional cost, how do I go about doing that we already talked about the what. What will I be entitled to, and when will I be entitled to the additional costs? And then you move to the how am I going to get paid for that? And that's important. It goes back to what Ingrid said, that everybody get on the same page here before the relationship is completed, so that there are no surprises at the end of the project and everybody leaves happy. So I'm going to talk about it from sort of the most sophisticated type of clause you might see, and we can kind of walk it back as to what you might want to put in there if you're working on a smaller project, or how to address a change order clause on a smaller project. And so the first is, who is authorized to direct a change order? Now, again, on a smaller project, that question sort of is a rhetorical one, because you're probably dealing primarily with the owner of the project, and there may just be one of them, and it may be a small company or just an individual that owns the project, and it's pretty clear who's authorized to direct changes. As you move up the sophistication in a project, however, there's often different people on a project that are authorized or appear to be authorized to direct changes in the work. There are foremen, there are superintendents, there are project managers, all of which have some level of authority that's been granted to them by their employer. And so it needs to be clear who exactly has the authority to direct me to do something different than what the contract calls for, or who is it that has authority to say that they will pay for something. Because if it's some Joe Schmo out on the project and they direct you or authorize you to do work, and that person didn't have any real authority to do that, they just pretended that they were important, you're going to be out of luck, because the owner may come back and say, well, I never told you to do that. I never authorized that. And that person that told you to do it isn't authorized as well. So it's important to determine in the contract who it is within the client organization that is authorized to direct changes and to approve changes. Okay. Now, the next is, if you have a change and you've encountered something that you believe you're entitled to under the contract, to additional compensation or additional time to complete your work, when do you have to notify your client of the claim? And many contracts will say it's as short as 48 hours. The AIA, I think it's just been changed to 14 business or calendar days, but some claims are still permitted within 21 days. But it can be as short as, like I said, 48 hours. When you encounter a condition, if you're encountering a condition, like we just talked about, that is different than the drawings or different than what you could have reasonably anticipated, and that condition is going to cause you to incur additional costs and additional time, and you intend to seek compensation for that from your client, you need to be aware that certain contracts give you a deadline to advise your client of that. Don't wait to the end of the project to submit a bunch of change orders and say, oh yeah, 3 months ago, I encountered the load-bearing wall. Here's the change order for that. When there's a contract that you signed that says you need to present at least notice that you intend to seek compensation, you might not have all your numbers ready yet within 48 hours, because that's an enforceable provision. And when I'm, again, depending on whose side I'm on, if I'm representing the owner, I am putting very strong language in my contract that says, if you miss the deadline, you waive the claim. And a court's going to enforce that. Those of you that participated in the first seminar know that the court's going to look to that written contract. It's going to use the plain terms and meanings of the contract as to what the parties intended. And if it says waiver, the court's going to say, hey, you're out of luck. You waive the claim. Forget about who said what, when, and where on the project or what you were promised. That's not coming in. You have a written contract. So be aware. How long do you have to submit at least a notice that you intend to seek additional compensation? You may have additional time to actually submit your supporting documentation and submit how much it's going to cost. Often, and it's also important for your owner. Your owner may say, you know what, maybe we don't want to do it, or maybe we don't want to pay that cost. And in that case, it's important for you not to do any work not to go out of pocket for any work until your client is aware of it and until your client agrees to pay for it. Again, it's as much as a relationship tool as it is a sound business practice as well. The final thing that we talk about in change orders is, you've presented notice of your claim that you intend to seek additional compensation. But does your contract say how you must support your claim? What you must do to document your entitlement to the amount of money that you're seeking? And again, I put it on the axis that I just described. The more complex, the larger the project, the more complex the level of data that you're going to be required to present to your client in order to get paid. On government projects where we're talking about potential change conditions that could be in the hundreds of thousands, maybe even the millions of dollars. The minutia that go into substantiating those claims is you could fill a 4-inch binder for one claim. It's remarkable. And for a smaller project, you just may have to back it up with the time and the material through timesheets and the material that you purchase from your supply house to perform that work. But it's important to understand, how is it going to be documented and how are you going to submit that? And it's always been my experience, regardless of what your contract says, the more documentation you can provide in support of your claim, the more likely either is voluntarily going to be paid, but in the unfortunate situation where you have to go to court, the court's going to look much more, or the arbitrators will look much more favorable on your claim, the more it's documented. And one of the things that I've noticed with Fohlio is it does provide some opportunity for you to capture these costs. One of the things that I always chuckle at is that when a contractor, if I'm on the other side, a contractor's presenting a claim and they hand me my client a bunch of receipts from Home Depot or Lowe's. Well, that's not going to do me. That doesn't do you any good. But if you can somehow use those tools that are available to you, and Fohlio is a great way to start, is that in documenting your costs, keeping that data in real time, keeping track of the communication with your client, keeping track of who told you to proceed, who authorized the change, when they authorized the change, and how they did it. The software like that is going to go a long way, and you're going to be well ahead of I think your client in documenting and being able to substantiate change orders and ultimately getting paid for work that you should be paid for, and oftentimes are entitled to. And I see that all the time where clients are entitled to changes. It's clear that this work was not within the scope of the work. It falls within the definition of change in the contract. And then when it comes to document the quantum, as we say, for the change order, their records are a mess. So what good is that? You've performed all this work, you're otherwise entitled to it, and you have no way to substantiate the costs that you incur. And you may end up getting nothing or only a percentage of what you're entitled to. And that's true even when your client agrees to pay. Like I said, I often, as a litigator, I often look at it from the perspective of, okay, what am I going to need to go to court, and what you might be entitled to when you go to court. But that's just true when the client says, fine, I agree, this is a change, I'll pay you. Please, present your data to substantiate your costs. And if you can't do that, that's a shame, because there isn't a dispute and there's not a reason to get a lawyer involved, and the client's agreeing to pay you, and you can't substantiate your costs for your client. And I think it also just makes you look sloppy as well if you're looking to develop a long-term relationship with clients. So that's all I have with differing site conditions and change orders. And I'm happy to answer any questions you might have.
So actually, really quick, I do have a really, really short presentation here. And it has to do with, so it has to do with how to keep track of documentation. And I know this is everybody's favorite part of a project. And obviously I'm being sarcastic because documents are such a pain to keep track of. And unfortunately, there's no way to avoid getting your hands dirty with documentation because, like Wally mentioned, and we didn't even talk about this beforehand, like the more documentation you can provide, the better your chances of getting that favorable decision in case you do get to dispute resolution, or if you go all the way to litigation. And when you have all that paper trail, you have all that proof that supports your claim. So there's a better chance that you can, get paid for whatever claim you're making for change orders, and you don't have to go any further. Okay, so real quick, just a second here. Wally, if you could please click stop sharing so I can share my screen.
That work? That work?
Not quite. I'm so sorry, guys. We're using a new software today, and we're still kind of getting the hang of it.
Should I do stop video maybe? I don't know.
Yes, please. Let's try that.
How's that?
Thank you. That worked.
Okay.
All right. So okay. So real quick for the people who are not familiar with Fohlio, because I'm going to be talking about the software today, I have a super quick introduction to just the parts of Fohlio that is relevant to my discussion. So this is what your dashboard is like. It's like a supercharged Excel sheet is what we like to call it. And here is the download function, where you can download all sorts of documents like presentations, just images, things like that. Okay. So with this discussion, what we're trying to hope to achieve today is for you guys to learn about keeping track of associated documents and how to generate job site documents easily and not take you, several hours, and how to keep all of your stakeholders on the same page. Basically, if any changes happen, if there are any updates, which do happen all the time, these are techniques to, make sure that everyone has the latest version of documents. Okay. So first of all, let's talk about associated documents, especially with regard to materials. You have your documents column like so. And if you want to see the documents that are associated with, let's say, this particular material, all you have to do is click on this number, which indicates the number of documents that are saved to this particular material. So if you click it, it's going to show you all of those documents, and you can remove them or add if you like. Another tip is, let's say you have your change orders or all those contracts that you signed. You're going to want to have that accessible to everyone who is relevant to the project, whether that's a client or whether it's a project manager or your foreman on the site, so that, like we discussed, if there are change orders that need to happen, who is authorized to make those changes or to ask you to perform that extra work. So if you need to refer to those documents while you're on site, you're going to want to keep that accessible to everyone. So something you can do is create a separate folder for it and then upload all of it to that folder. Okay, So next thing that we want to talk about is is making sure that everyone is updated with the latest, let's say, specs on the project. What's really interesting is that this is something that I actually thought of yesterday when a user asked me about it, and they were asking, hey, if I want to generate job site documents for my guys, and I want to make sure that it has an indication on it that this is the latest version of those specs, how can I make that show on the document? So there are two ways that you can do that. So let's say you are creating a table view presentation. When you do that, when you are setting up your page, your PDF, there's a section for notes. So you can type that in there. You can put in the date, or, let's say this is version 12 or whatever. Another thing, and yeah, once you generate that document, it's going to show on every page of that PDF. Another thing you can do, and this is, of course, this is all dependent on how you work with your dashboard. Another thing you can do is create a separate column where you can just type in which version that is. Okay, and let's see. So when you generate job site documents, this is something that typically takes several hours to print out, because usually those installation manuals or specific spec sheets for a certain material, often a lot of that is in several different places, so you're going to have to access it one by one, print it off one by one. In Fohlio, in case you're not using this yet, here's what you can do. When you go to single product presentation, there's a section here where it allows you to select all the product documents that are related to your materials. And what that will do is it'll give you a list of all the associated documents, and you can just select whatever ones you want to print out. Or you can select include all, and that will print out every single document that is associated to that folder or subfolder that you're wanting to print out. So if you would like to get a demo for how all this works, and if you have other more specific questions about the product, please visit us on Fohlio.com. You can schedule a demo with us for whenever is best for you. You can also email us or give us a call. And with that, let's go back to questions. Does anyone have questions for Wally or me?
Okay. Easy crowd. Okay, easy crowd.
Oh, here we go. Oh, actually, just a thank you, Wally, from Ahmad Neo.
Okay. Thank you. You're welcome.
Oh, here we go, from Misty. Okay, how about a time for the client to respond to your change request? So because there's going to be a clause in your contract about within 48 hours, you have to produce a change order request. What about for the client? How long do they have to respond to that, or how can you work that into your contract?
Yeah, I think it's a good idea. It's a good point that you bring up. If that's an issue for you, and you think that the client's going to delay in getting back to you, it should be addressed in the contract. I actually had, and it's funny you bring it up. I actually had a major case involving a building at the University of Pennsylvania, where a large portion of the case was just that scenario, where the client, my client, was submitting drawings to an engineer, and the engineer was just sitting on them for weeks at a time. And these weeks and weeks and weeks started adding up because they needed to get the drawings approved by the engineer back in order for them to proceed with their work. And that was a very sophisticated project and contract. And there wasn't anything in there that said how long the engineer actually had to respond to these requests to approve drawings. And probably one of the reasons why it ended up with me. So I think absolutely, if it warrants it, it's a great concept. Is that to the extent that I'm going to be requesting, I would say really approval for anything. Go ahead and put a time frame on there, and then if the client takes too long, then it would automatically result in an extension of time or additional compensation to you. Yeah.
Yeah, that was a really good question. Okay. Oh, here we go. So from Ahmad, what happens if some of the work or materials of the change order are not listed in the breakdown price of the contract? How should the client evaluate such change orders?
Well, I if I understand the question correctly, it's if the basis for the quantum of the change order is not set forth in a schedule of values, as we say in the industry, how do you evaluate it? Well, if it's a change order, it's probably not going to be set forth in the schedule of values. So you're going to have to evaluate it based upon the data that is provided by your customer in order to substantiate its cost. I think that whether or not there's any sort of link to the underlying scope breakdown is of less importance as to whether A, they're even entitled to it in any event based upon the language in the contract, and if they are, whether the data they have to substantiate their cost that is submitted in conjunction with their change order makes any sense.
Okay. And we have a question from Diane. She is a designer. So the contractor is presenting their contract. If it lacks what has just been discussed, do we ask for the clause? Do we write it ourselves and submit it as an addition to the contract? I'm looking for protocol from the contract / receiving end. This is a really good question.
Well, I think you just got to go back, and ask your contractor to include it, and have them amend the contract. And if they say, well, we don't have this, and the reason I say that is, well, I shouldn't make assumptions. I think the last industry that uses fax machines on a regular basis is the construction industry. So I shouldn't assume that they have all their documents in Word, and it shouldn't be too difficult for them to amend their contract to include that clause. But to the extent that they don't have their contract in a Word-based format that's not easily amended or revised, or they can share the file with you to do it, sure, put it as an addendum to the contract. Obviously, make sure that they sign off on it. Make sure it doesn't conflict with the other provisions of the contract as well, or have some language in there that says it supersedes it. But certainly, like I said, there's got to be. I highly recommend that is having some sort of protocol to deal with what is going to be compensable and how you're going to be compensated.
Okay. All right. When we have a design and build contract, what is the strategy with change orders or claims? Ahmad, are you asking about?
Yeah,
Go
I could answer that. If you got a design build contract, the concept of design build is that uh, the owner's not going to have any change orders because you're designing it and you're building it. So they're really, that's I guess the theory of design build. Now
Mhm.
there are certainly examples of even when there's a design build where there could be change orders. Where that would occur would be when the owner directs you to change the design to such an extent that it's additional. But generally speaking, the theory of design build is that the design builder assumes the risk of and responsibility of designing the project to meet the owner's intended result, and then to build it within the budget that it has presented to the owner. So in a design build scenario, if you're the design builder, you better know that before you get into a contract, a design build contract, that it's going to be very difficult for you to come back and say, or impossible to say, well, it's not a situation where something on the drawings could differ than what you build, because you're responsible for the drawings. Like I said, there could be situations where the owner tells you to change the basis for the design. That's going to be an area where you're going to be entitled to a change order. Or if the existing conditions, if it's design build of a new project. But even that is going to be more of a challenge, because the owner is going to turn around and say, it's design build, you own it, and you should have made yourself familiar with the site conditions before you prepare your design. So don't come to me and saying that the soil or the surrounding neighborhood or whatever it is was of such a character that your design had to change. So in design build, I think it's really limited to those situations where it's the owner that is driving a change in the concept from what was originally anticipated.
Oh, I do have a question about this. So when it's a design build contract, basically the key here is that you are assuming most of the risk or all of the risk here. But going back to what you said about different site conditions, that it's not a reasonable thing for you to know that the conditions are materially different from what you're expecting. How do you deal with
Sure.
that?
So sure. So when we talk about something like design build, um, that is what's known as a project delivery method. And there are several types of different project delivery methods. Design build is a popular one, but by far the most popular, and really what my presentation is geared towards, is design, bid, build. That's your common standard procedure for procuring and delivering a construction project. There is an entity that designs the project, the design professional, the engineer or the architect. They design it, they prepare a set of drawings based upon the owner's desires. Then the contractor who has to build it submits a proposal based upon the design. Design, second part is bid. And then there's the building. The contractor, if the bid is accepted, undertakes the responsibility to build the architect or engineer's design with its forces or with the forces of subcontractors. So most of the concepts that I'm talking about are going to be mainly applicable to those design bid build scenarios. It really is, if you're talking about the project delivery method of design build, what you're doing is you're collapsing those first two. Is that the contractor takes on there is no architect or engineer that is separate from the contractor that prepares a set of drawings that indicate the owner's intended desires for a contractor to build it. If you're a design builder, the owner comes to you and says, here's what I want, and how much is it going to cost? And I don't have any drawings, and you figure it out. And you undertake that responsibility. So it's a fundamentally different relationship if you're a design build contractor than if you're just an ordinary contractor that is building and submitting a bid off a set of drawings that are prepared by a third party.
Okay, all right, thank you. Any more questions from the crowd? We do have a few more minutes. All right, I think we are all good for today. Anything else you wanted to add, Wally?
No, that's it. Like I said at the conclusion of the previous presentation, all my information, my email address is the best way to get in touch with me. It's at the first slide, Wally at zimolonglaw.com, and probably on the Fohlio website. Instagram, Facebook, all that, you know, you can take a look at it, LinkedIn. But as far as contacting me, email is the best. And if you think of any questions that come up based upon what I talked about today, just feel free to give me a holler.
Okay, and you also know how to get in touch with us. Just go to Fohlio.com. We have a live chat. We do have a live chat, and that is monitored all the time. So we are going to be able to get back to you pretty quickly. Okay, well, thank you everyone for coming today, and thank you, Wally. That was, again, super duper informative. We will be sending out the recorded version of today's webinar. And all right, Diane, we are also looking forward to next week. Thank you. Have a good day, everyone.